Hi, welcome to Property 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. In this series, we are looking at four fundamental questions, and today we are talking about the second one, which is how can we acquire property? Among the many doctrines by which we as Americans decided to entitle people to ownership is the doctrine of discovery. There is this romantic narrative of the American frontier, this notion that territorial expansion was tied to our manifest destiny as Americans. The reality of frontier expansion, however, is a really horrific land grab, first by colonists, then by new Americans against Native American tribes. Ultimately, something like 1.5 billion acres of land was taken in a very short period of time. We are still reckoning with the consequences of this theft, land grab, whatever you want to call it today. So Americans used the law to justify their conquest. The discovery doctrine had been used before, largely by white dominant European nations for centuries. So the Portuguese, just one example of this, used the doctrine of discovery to make claims in West Africa that the country decided would help boost their slave trade. And that was all the way back in the 15th century. The European context is important because it shows why the US Supreme Court in 1823 decided to sanction the use of the concept of discovery as Americans expanded west. So the specific case that we're talking about today is Johnson versus McIntosh. Again, 1820s, very early in our nation's history. The dispute itself is about land that was tribal land, but the parties to the dispute are not members of tribes. Instead, they are two people who asserted different claims to what was supposedly the same land. As an aside, we found out later that it may not have been the same land, but just put that aside for the purposes of this discussion. One of the parties, Johnson, claimed title through an ancestor's purchase of land from the Piankashaw and Illinois Native nations. As you read the case, you might ask yourself how this purchase came about in the first place. And so I'll tell you that, especially during the colonial period, there seemed to be an acknowledgement that Native Americans, that tribes could own land. When colonists were considering how to take land from tribes, they realized that the land was not that expensive if they just purchased it, and also that they probably didn't have enough power to take most of the land by force. So in Johnson's case, as was the case with many colonists and their heirs and assigns, they acquired the land through a purchase. The other party, McIntosh, claimed a title to the land through a patent from the US government. At the time, land patents were becoming an increasingly well-used way for government to transfer ownership to private parties. And so essentially, this is a dispute about the chain of title, and it goes back to our question of what the root of title is. We cover the chain of title, by the way, in videos for question 4, how can property interests be held? So getting back to the case, in looking at these claims, Chief Justice Marshall weighed the prospect of acknowledging native title, which again is something that had been happening for many years before this case, weighing that against the sovereignty of federal government decision-making. In the end, he articulated a vision for the United States' dominance over tribes. So let's look at some of the phrases he used. He said tribes held a mere, quote, right of occupancy, end quote, but not ownership. As noted, this demotion to mere occupancy instead of ownership differs from the practice of many colonists to recognize tribal ownership, at least to the extent that they purchased land from members of tribes. Instead, Marshall says, tribes were subject to ultimate dominion of the United States, a principle rooted in white supremacy and in Europeans' use of discovery. As he did in the Antelope decision, covered in another video in the series, Chief Justice Marshall talks about positive law. So positive law that exists, the law that has been adopted or made under proper authority, whether it's legislative or judicial. In other words, using these positive law, using the European precedents, he says only the federal government, which represented white male landowners, had the ability to transfer tribal property, not the tribe that had stewarded the land for centuries. So in thinking back to the context in which Marshall was making his decision, a young country at the time, eager to expand its economic power, could it have been possible that he was also thinking about the efficiency by which the country recognizes title in land? It would be easier and clearer to administer competing claims if there was one dominant source for land claims. So to the extent that that is a more charitable explanation of his motivation, we should also ask ourselves whether efficiency is always a value the law should prioritize over others. It's my hope that as you read this case and you think about Western expansion, that you put aside the romance and the myth of our move out west and consider more seriously about how property law was used to dominate, to marginalize, and to reduce the wealth and power of tribal groups and others. And I ask you also to consider how property law continues to do this today. So I'll leave it there. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to mailing list. See you next time.